Assalamu alaikum. Peace be upon you all and welcome to the Sharia Intelligence course. I am your host, Muhammad Nuruddin Lemu, and with me to discuss today's topic are two of our top facilitators, Sister Salatu Sule and Brother Ibrahim Bello. You're most welcome. Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
Today we will be looking at one of the very important secondary sources of law. In the Hanafi school, it's actually the third used by scholars usually after the Quran and Hadith Mutawatir. It's called istihsan, usually translated as juristic discretion or juristic preference, or the preference of the mujtahid, the jurist. This is one of the three reason-based tools called istidlal, which include maslaha al-mursala or masalih al-mursala, istihsan and saddu zariya, preclusion or blocking the means to harm, as we will see inshallah in the next lesson. Istihsan, along with these other two, maslaha or masalih al-mursala and saddu zariya, usually act as safety nets. If we use the metaphor of safety nets from the field of the entertainment industry, the circus, where people are involved in gymnastics from one trapeze, just gymnastics in the air, there's usually a safety net there to catch anyone who falls and prevents harm or prevents anybody from killing themselves. Istihsan, saddu zariya and maslaha play the role of a safety net, so that in the ijtihad and in the intellectual gymnastics of the jurist, these three ensure that harm is not caused as a result of ijtihad. These three ensure that whatever diversity of opinion is going to take place, ijtihad does not end up creating mafsada, does not undermine the spirit and the objectives of Islamic jurisprudence. The first question I'd like to ask our colleagues, starting with Sister Salatu, what exactly do we mean by istihsan? Why is it important when it comes to Islamic law, and how is it similar or different from masalih al-mursala?
Okay. Istihsan is what is called juristic preference or juristic discretion. It's taken from the root word hasana, something that's good or excellent. When we use the term istihsan, we are talking about that process through which a mujtahid, a jurist, decides which tools to use in order to secure benefit. It's not just deciding which tools to use, it's actually choosing to use one tool rather than another, to make one ruling rather than another, with an eye on public benefit or public interest or the common good. This is quite similar, of course, to masalih al-mursala, but there are some nuanced distinctions, especially when it comes to how the terms are understood, generally speaking. When we say istihsan, we are actually looking at a situation similar to what you might have when a surgeon goes into the operating theater. The surgeon goes in, has an idea of what condition did the patient present with and what procedure does he or she intend to carry out. However, while that patient is on the operating table, the surgeon has to always make the decision or the choice about which particular surgical instrument to use at which time and for what. Also, you have cases where surgeons say they go into the theater, they open up the patient, they already had their plan in mind, but as they open up the patient or they start the work, they realize, use this tool, not that tool, do this, not that. In some cases, the choice becomes, you know what, close the patient back up, take the patient back to the ward, we need to go look again or sit down again and consult some more to know how to proceed. This is similar, if one wants to hold a picture in one's head, that's similar to what a jurist does when the jurist is using this particular tool, istihsan, that is going by way of discretion or preference. Other examples include the question of when a chef is in the kitchen or someone is cooking. You've got your knives and you've got different kinds of knives. You've got spoons and different kinds of spoons. You've got some of these contraptions that have different heads, and the chef has to decide, take this head out, bring that one in, because you want this effect, not that effect. It's also similar to choosing between one lane or one road when you're going on a journey and another. These are just metaphors to help us understand that at the core of it, what is istihsan? When we then say, okay, let's put istihsan side by side with masalihul mursala, maslaha, because both have this concept of securing benefit, we have to then say, okay, how do we distinguish them? So at least when we talk about them, when we say this is what the jurist has done, we understand what we are all talking about. When it comes to maslaha or masalihul mursala, the focus there is on what is the benefit, what is that public interest, what is that public good you want to secure. So there's a what factor that's underlined there. With istihsan, there's more of the how factor. So if the aim is to secure public benefit, when a jurist is using the tool istihsan, working based on his or her preference or discretion, the jurist is now looking carefully at this tool rather than that tool, this ruling rather than that ruling. So that's the how factor. Another way people distinguish them is to say, when you talk about masalihul mursala, you are looking at a situation where the jurist grants temporary permissibility to something that is otherwise prohibited, simplistically put. When you talk about swadu dariya, which we'll talk about soon, that's when you are saying swadu dariya, that is where the jurist is going to grant temporary prohibition to something that is otherwise permissible. Istihsan is the tools, the procedure, the process, the choices the jurist has to make, whether the jurist wants to grant temporary permissibility or temporary prohibition. So these are some of the ways of understanding the relationship and similarities, differences, interaction between istihsan as a tool and masalihul mursala as another tool, and swadu dhariya, which we'll discuss soon, inshallah. And together the three then form, or they then belong to that group, istidlal, reason-based tools for jurisprudence.
Interesting. Brother Ibrahim, what would you add on this?
Now, like she said earlier, simply put, istihsan is to abandon by way of exception the law. If applying the existing law would mean departing from the spirit or clash with the objective of the law. Simply to say, if the letter of the law clashes with the spirit of the law takes precedence. So, what that means is to say, if there is a provision for a particular thing to be done or prohibited, if we were to go by what is on ground, but then we look at what might follow. Applying it might make life difficult. It will create greater harm. Then looking at the intent and the spirit of the law, we suspend applying these, which in our case might mean permitting what is prohibited, just to solve a bigger problem. So like she said earlier also, it is a consequence based. Like they are looking at the consequence. If we're to do this, what might likely happen? We can't, okay? There will be difficulty, there will be challenges. Islam will be misunderstood. It might even force people to get worse, whatever situation is at hand. Then the jurists will now say, okay, I prefer this. That's why they call it istihsan. Yani istahsanahu, yani he gave this preference over the other. So that is why it is called istihsan. So for this reason, scholars will say istihsan makes a scholar a scholar, is what makes a distinguished jurist a distinguished jurist. A number of reasons are advanced for validity of istihsan as a tool. Allah subhanahu wa ta'ala will say, وَاتَّبِعُوا أَحْسَنَ مَا أُنزِلَ إِلَيْكُم مِّن رَّبِّكُم. Follow the best of what has been revealed to you from your Lord. Allah subhanahu wa ta'ala also says, الَّذِينَ يَسْتَمِعُونَ الْقَوْلَ فَيَتَّبِعُونَ أَحْسَنَ. Okay, those who listen and choose to follow the best. The Prophet sallallahu alaihi wasallam advocated for ease in various ahadith. Say, ad-din yusr, in the religion is easy. The best of your religion is what makes easy. And then whenever the Prophet ﷺ is faced with options of choosing between what is hard and difficult, what is easy and what is difficult, he go for the easier one. Also, this is also supported by the maqasid of Sharia, the spirit of Sharia, which says that al-mashaqqatu tajlibu taysir, that hardship calls for relaxation or easing of the law.
The maxim, yeah.
Yeah, la yukallifullahu nafsan illa wus'aha. Ad-dararu yuzal. Harm must be eliminated. So this is why istihsan is important, and this is the long and short of it. So and when we come to exams, we see clearly what exactly that will mean.
This is interesting. One metaphor, I think, this issue of changing instruments, and I know some have described istihsan as being like an adjustable spanner, as opposed to a normal spanner, one that can expand, it can contract, it can do more than just permitting good, it can prohibit, which is why I think sometimes the Hanafi school look at istihsan as being the tool that does everything that Maslaha and Saddu Zariya and others would do. I know some have also explained it as similar to changing forms of transport if you are late to catch a flight or you're running late. You're going to the airport, you're in your car, you meet a traffic jam, and you decide the car will not allow me to achieve my objectives. That would have been the normal law, the normal way of doing things. I'd need to get onto a motorbike or get onto some other means of transport. And that changing from one legitimate tool to another legitimate tool to realize the spirit and the objective of the law is described as istihsan. For those who distinguish istihsan from Masalih al-Mursala. You've started giving some evidence for the validity of Masalih al-Mursala. For istihsan, juristic preference. Sister Salah, what could you add regarding the validity of this?
Okay. There is a classic case that is very often cited for various purposes, which I think would be instructive here. It's the case of two people who had stolen a camel and they were caught, reported to Umar radiallahu anhu. When the case was reported to Umar, at first he went by the letter of the law. If a person steals, it's established the person has stolen, the punishment is cut the hands. So that was his pronouncement. But these men then pleaded their case and stated that they worked for a particular man. They were his servants. In some narrations, they actually say they were his slaves. Wallahu alam, they were his servants. And they stated that this man wasn't meeting their needs, which is why some would say they were his slaves, because there's a heavy weight put on anyone who has slaves, care for them, feeding, clothing, everything. So these men protested that he wasn't meeting their needs. They worked for him, but he wasn't giving them sufficient care. And that was what pushed them to go and steal from another person. The owner of the camel was there, of course. When Umar heard this part, he then sent for the owner. And he asked the owner of the camel that had been stolen, what's the value of your camel? And the owner said 400 dirhams. And Umar then told the master of these two men, pay this person 800 dirhams. So it was the exact value of the camel, then doubled it as punishment and compensation for the inconvenience of everything. So you could see a lot of agile thinking going on here. Not only that, he then said to the master of the two men that take them back and look after them well, meet their needs, clothe them, feed them. If they steal again, because you are neglecting your duty towards them, I will cut off your hand, not theirs. I remember the first time I read it years ago. As I said, when I was doing all my exploration, trying to understand Islam, what does it mean to be a Muslim? I knew I was like, wow, now that's interesting. You know how you hear a story or you watch a movie and you say, I did not see that coming. But here you see someone, Umar radiallahu anhu no less, knowing and understanding the clear letter of the law, but also understanding the spirit of the law. What are you punishing? What are you sanctioning? Is it just the action? Or is it in a sense, the circumstances around the action, the thinking that preceded this action? So he took those steps, departed from the clear letter of the law, and then gave a judgment using this, what we now call this tool, istihsan. Istihsan has been viewed as a very important tool because of the function it plays, the role it plays, how it helps ensure that usul al-fiqh, this particular field, is not disconnected from the maqasid al-sharia. So it acts like a maqasid compass, helping to continuously point the exercise of ijtihad, this cognitive exploration to find the best answer to every problem, to continuously point that exercise in the direction of the maqasid. It also helps to align usul al-fiqh, the use of whatever tools, because as we mentioned before, istihsan allows a jurist to say, I'll use this tool, not that one. I would do this, not that. It therefore allows that when using these secondary tools, these cognitive and reason-based tools, the jurist is still in alignment with the maqasid. Especially when you say istihsan, what is the jurist thinking about? Public interest, common good. So it allows that flexibility, and again allows, just like Masalihul Mursala, allows the jurist to engage people who know, people who understand what is going on in the context, experts of the context. So it allows that broader consultation that therefore enriches the outcome that the jurist has in mind. Lastly, it's also, outcome-based, consequence-based. As we know that primary maxim that al-umuru bima qasidiha, every action you will judge it based on the intended outcomes and also the outcomes that are foreseeable. So the jurist will continuously bear in mind, if this tool is used, what will the result be and what would be the impact of that result, benefit or harm? This is why this tool has been found to be very, very useful, because it helps balance the jurist as he or she navigates through these different secondary tools.
Thank you very much. Allah Ibrahim, what would you add to her discussions?
Yeah, just like she said earlier, istihsan is about where exactly are we going if we start having difficulty with our route there. If the ideal route is not taking us there, the scholar has that choice, being concerned with the consequence. And that's why it's a very good tool in fatwa. It just temporarily permits what ordinarily is haram because of. And so it's context-based. It shouldn't be forgotten and depends on who speaks. A number of examples also, like a case of when Umar was confronted with a case of sharing inheritance. A man dies, leaving a wife, mother, 2 uterine sisters, and 2 half-brothers. Now, going by the formula given in Quran, the wife has a fourth, the mother has 1/6, and the uterine sisters actually take 2/3, the remaining third, 2/3 really. And the brothers protested. They say, yeah, Umar, because they are residual heirs, people who ordinarily should inherit after every other person. And they protested. They
because they were getting nothing.
They were getting nothing. You mean if our parent was a camel, we don't have anything?
No, donkey.
Donkey, really. Umar understood very well their plight. So those that were having the share, the mother and the wife, he left their own. And he took the third that is left for the uterine sisters and redistributed it. So why did Umar do this? This is exactly istihsan. Going by the ideal, the provision of the law now clashes with the intent, the goal of Sharia. A number of scholars, for instance, recently ruled that a man actually made a case in one fatwa council that he lost a mother. He is the only son. And she is not a Muslim, and he is a Muslim. And in fact, the policy of the country and the people there, they are actually harry. They are fighting Islam, they are fighting Muslims. And the scholar ruled that go and collect your own share of the inheritance. Don't leave it for them. Even though the Prophet said, La yarisul Muslimu kafiran. Why? because you look at the intent of Sharia. So these kind of things are called istihsan, and a number of it abound. Scholars do that, Sahabas do that. Once life is at stake, what else do you do? And it's usually based on the fact that if Islam say you can eat haram to survive, because the intent is what? Survival first. So this is why istihsan is important. These are some of the examples we can add here.
This is very interesting. What you're saying is there's the normal law,
Yes.
and there's where it's clear the normal default law will not realize its objectives. So we're dealing with an exceptional situation, and istihsan is that moving to a different rule because of an exceptional situation where the default normal law will not achieve the objectives of Sharia. So you basically solve the problem by dealing with it as an exception, and in that sense, the exception is not the rule,
Yes.
but actually helps us recognize the rule. It's exception that makes us understand this is a temporary solution for this case. But when we don't have that case, we go back to the normal. Sister Salah, what can you say regarding the fatwas that have been given? What examples can you share of jurists, past and present, that have used istihsan to produce rulings on various issues? Any examples?
Yeah, let's take an example from Hajj. A well-known jurist of the past, Ibn Taymiyyah, actually used istihsan to grant permission to a woman to perform one of the rites of Hajj, which is the tawaf. That's the circumambulation, which is compulsory, but if a woman is in her period, she suspends that and she completes it later. But he then said in a case where a woman is traveling with a group and the group cannot possibly wait for her, even while her period is still on, she can perform that particular act of Hajj. That's one. Another case where you have scholars in more contemporary times relative to Ibn Taymiyyah making rulings with regard to Hajj, again relates to women, where you have a similar situation. A woman is traveling with a group, she doesn't want to be left behind if her period comes up during Hajj. But you now have pills, contraceptive pills, a number of them, that actually have the effect of stopping periods. And the questions kept coming up. Can a woman take such pills and then go on Hajj? Technically, she's still on her period, even though there is no actual flow of blood. And you have rulings being given that, yes, she can take such pills and do her Hajj within the normal space of time, which, when you think about it, actually makes it more convenient for her. So it's that same thing of interest and good, of the general good. Now, we also have another case when it comes to law of marriage, where a woman who becomes a Muslim, but the husband is not yet a Muslim or has not agreed to become a Muslim. What happens to that marriage? Does that marriage continue? Should the marriage be immediately revoked? Does it immediately invalidate the marriage? The ruling given, generally speaking, you might have differences of opinions, is that marriage still subsists. Condition being, or rather the consideration being, what is in the interest? What is the interest here? What good would it do to break up such a marriage? And just again to reiterate, when it comes to istihsan, the jurist is concerned about general good, but is also able with istihsan to focus on the good for this individual. So there's that two-sided thing to it, or an extension of it, the good or interest of the person in question, as well as consideration for generally speaking, especially where you say if this were to keep happening, and so on and so forth. Another example of istihsan coming into play is where we talk about the law of inheritance. If a child who is born out of wedlock, but is acknowledged by the father as this is my child, even if the child was born out of wedlock, you have the general principle saying those who are automatically entitled, or you can grant your will to, are these people. And the jurist can then consider, out of, using this tool, istihsan, to say if this child was acknowledged by the father, then the child can actually inherit from the father. Again, as we mentioned some of these examples, we are not saying all scholars agree on these things or there aren't variations in how they're understood, but we are just highlighting cases where scholars in the past and more contemporary scholars have used istihsan to arrive at some of these rulings. These are some of the examples I have.
And just to underscore, I think it was Ibn Taymiyyah, along with others, who take it that so long as the father agrees this child is his, then it is his child and he has a right to inherit.
Yeah.
Others disagree on that position, but istihsan is what, as you said, the jurist then uses the difference of opinion to see what is fair in this particular case or in this context. The other one you brought, I think, was raised by Ibn Qayyim, where a woman embraces Islam without her husband, and Ibn Qayyim mentions about 9 different opinions scholars hold regarding what's the fate of that marriage. And as you said, it is now, of those opinions, the majority will say the marriage is broken. They differ on just the length of the iddah before that. However, of those opinions also attributed to Umar bin Khattab, attributed to the Prophet in the case of his daughter's marriage, Zainab, the other attributed to Ali, that when there is such a case, the marriage still stands. And so istihsan becomes a tool that is used by scholars where they feel there is no need to break this marriage. The marriage is healthy, the woman is not threatened, her rights to religion are protected. Then they would go with those opinions instead of what would you call a majority opinion. Malam Ibrahim, what else would you add as examples of istihsan in action?
Yeah, istihsan in action. Think of a case of a family that were not actually married officially. They just came together and lived together and they relate as husband and wife, but no contract. They had children, they were Muslims, and maybe years later they come to realize that there was a problem. They have studied Islam, they have understood Islam, and they are now seeking fatwa from scholars. What do we do? Okay? If you say their marriage, the children are born outside wedlock, there was no marriage, automatically those children will not inherit. That has a lot of consequence on the children and the family. Even in the society, before society come to see them as husband and wife, they didn't even know that they were not officially married. So istihsan was what was used by a scholar who was asked. And he said, you know what, simply put, treat their case as those that were coming from Jahiliyyah and accepted Islam. And life carries on. They don't need to remarry. And that was fine. Because ordering for another new marriage contract also calls for a lot of questions. Yeah. So this scholar says...
Especially in some environments like some of our own where...
So looking at his environment and the reality and the consequence, and that some of these children have even understood Islam, this and that, and the man has regretted his action, he said, we treat your case as those of Jahiliyyah. In Jahiliyyah, these kind of things will happen. And since they relate as husband and wife, the parents didn't consent. Like, there was no need for parents' consent. That was the kind of setup they were coming from. This is fine. It's istihsan. And a number of similar examples also. Okay, you have a case of a man who reported a case of, look, my wife, this child, I am suspecting that I am not the real father of the child. And the scholar said, do you have witness? He said, no. Can you do li'an? He said, no. He said, keep quiet. Accept him as part of your children, and that's all. So why? It's his son. He is looking at, if you are to say, okay, since you are not sure, this and that, let's go to court, let's drag. He's looking at the consequences. So this is it. Now scholars from various schools of thought have their own positions and how istihsan has actually helped them. Okay? Like Shafi'i is the only person that actually did not accept istihsan as a tool. Shafi'i and maybe the Zahiris. But Hanafi, Maliki, and the Hanbali were very much at home with istihsan. And they made use of it in a number of ways. A number of fatwas have been influenced by this, including most of the fatwas of Hajj. In fact, scholars have it that if you have a case of where there is like divergent opinion regarding an issue, but you are a dawah person, you can tolerate. Another typical example is a scholar here went for dawah in some part of the country where they are Malikis. So they don't pray with their hands on their chest. He's used to praying with his hand on his chest, and they only agree with one salam, assalamu alaikum. They're saying other than that, completely they condemn what you come. They don't want to listen to you. So while he was going, he advised his students, you know what, from our conviction, you should pray with your hands on your chest, you should do this and that. But this is where we're going. This is the essence, this is what we want to achieve. It's not that you are dismissing sunnah, but pray like they pray, so that we get to talk to them and they will understand us. So this kind of rulings, and a number of them, where scholars, because of unity, humility, brotherhood, where there are differences of opinion, or you can even suspend something that is mustahab, just because of a greater achievement, or because doing it might cause a bigger harm. They do that in Hajj. They do also talfiq, where scholars will agree that, okay, on some of these issues, let's look outside the box. Let's look beyond our mazhab. Why? Because they have potential of solving problems, and they, by so doing, they accept the weakness and the shortcomings of their own standpoint. Yes.
Jazakallahu khairan. I think this case of talfiq, where a scholar in one madhab goes, instead of getting creative and coming with new ijtihad, you borrow, if it were, or adopt the fatwa or ruling or position of another madhab, is something we've seen becoming more and more common from fatwa councils, especially in a more globalized world, where in Islamic finance, for example, nearly everybody inclines towards the Hanafi school on issues surrounding contemporary zakat, on issues of Islamic finance, in the area of the right of a woman to divorce her husband and get a divorce, whether the husband agrees or not, which is the Maliki understanding of khulu. We find other schools, the Hanafi, Shafi, and Hanbali, actually inclining when they're having legal reforms. They move with the Maliki position on this. We find in areas of giving zakat to non-Muslims, we find the difference of opinions being used, especially where Muslims are a minority and they have serious problems with the non-Muslim majorities. The crowding also in Hajj has made a lot of people go with the Hanbali view that has a lot of variety there. I think we've got a lot of these type of challenges that has created, has allowed istihsan to be the method of benefiting from the bigger toolbox of the various schools of thought. What other evidence, for example, would you give for the validity of istihsan?
Yeah, like I said earlier, the Prophet ﷺ said, Ad-Dinu Yusr, the religion is easy. And more so, Islam is a religion that has intent and goal. The Prophet ﷺ, for instance, had a choice why he went to Ta'if to invite them to Islam. And he was harmed. They stoned him, they wounded him like that, so to say. And Allah subhanahu wa ta'ala sent Angel Jibril, whether he will pray that they should be crushed. But he said, no, I am looking beyond just them. So that is exactly what Islam is. We look just beyond them, but what is the goal? So, the Prophet ﷺ did not pray for them to be crushed. So this, and looking at the generality, the bigger picture of Islam, and what scholars have done in the past, starting from Umar and others, to temporarily suspend or permit what ordinarily will be haram because of what it will lead to. And because of this flexibility that, okay, if you have a difference of opinion, it actually becomes now an advantage. Ordinarily, if you are coming from Maliki standpoint, you can't give Zakatul Fitri in cash. It has to be in kind. But we are now having a globalized world. In places that are highly developed economically, they are okay. You don't even know who to give zakat. So it becomes an option that in such communities you can give
Zakatul Fitr in
Zakatul
cash.
Fitr in cash. You can
It's really
monetize
more
it.
cosmopolitan
Exactly.
societies.
So these are some of the options.
Wonderful. Could you say a bit more on the question of the differences of opinion? You started on Maliki, Hanafi, holding some views, Shafi disagreeing. What more could we say on the differences of opinion among scholars on istihsan?
Yeah, a good number of them are like saying istihsan is a secondary tool. So it's debatable, simple. And all of them agree that it is useful. But that the ruling it produced, number one, is temporal. Okay, it's not permanent. Number two, is that it is not binding because it is not Quran and Sunnah. Number three is a fatwa tool, okay? As long as the scholar that issues it, the condition and the context remain, it remains valid. But aside that, Shafi'i that rejected it and Zahiri actually agreed in principle. They agreed in principle, it's only that they use a different approach or different tool. They use urf, they use istishab, but they end up saying the same thing. So these are some of the differing opinions of scholars and why scholars will continue to disagree. More so, it depends on the issue at stake. Whether it is considered to be weighty enough to allow permitting what is ordinarily haram. This is another point of contention. So in that sense, studies or impact assessment and what have you will also be very useful. So that whosoever is issuing that verdict will actually have a proof to show, look at this. And this is what justify this fatwa.
Excellent. Sister Salah, what would you add as we come to the end?
Yeah, just to add that for many scholars, many jurists who use this tool, what they enjoy is the flexibility, the adaptability, that they can move from condition to condition and context to context and still stay within the purview of what it means to be a jurist and still be able to achieve those aims, the higher aims and intents of Islamic jurisprudence. The openness it also allows when it comes to doing impact assessment is equally useful for jurists to make them actually achieve the aim, what they intend, not to go just by way of will it work, will it not work, is it harmful, is it not harmful. That's going beyond the theory to the actual practical aspect.
Thank you very much. So one of those things that we take from this tool, istihsan, firstly, is it belongs to the safety net tools, if we use that metaphor, side by side with maslaha and saddu zariya. But what for the Hanafi school is like an adjustable spanner. It does the job of all. It is, of course, a dhanni school tool. There's a degree of presumption. There's a degree of possibility of error there. And so like all the secondary tools of ijtihad, it is an area where there would be differences of opinion in principle, actually. It's a consequentialist tool, just like maslaha, just like saddu zariya, as we will see soon. It's a tool that is concerned with the consequences of actions, whether they will be in line with or contrary to the spirit, the purpose, the higher intents and objectives of Islamic jurisprudence. It is a tool that has allowed scholars to move from one source of law to another source of law in pursuit of the spirit of Shariah. It's a tool that is really flexible. It's becoming more and more important as we move into a more rapidly changing world. It's probably the tool that has allowed the Hanafi school to actually adapt faster than any of the other schools in the rapidly changing field of Islamic finance. We'd like to stop there, inshallah. Next time we will carry on with saddu zariya, preclusion, and we will hear more about that, inshallah. Meanwhile, thank you very much for both of you for your contributions. Until next time, inshallah. Assalamu alaikum. Jazakumullahu khairan.